Okay, so I'm Denise Anderson Warren. I'm the city clerk, and I want to thank you for joining us for the Boards and Commission onboarding training today. Um, we'll be presenting some of the basics of the Brown Act, ethics and civility and conflict of interests. So before we get started, I just want to go over a couple housekeeping items with everybody before I make the introductions. So I'll ask that everyone please mute unless you are going to speak, and to keep your cameras off to save the bandwidth. You can turn your camera on when you go to speak or raise a question. We will have a question and answer period at the end of each section. But if you have a question that comes up while we're presenting, either raise your hand or submit your question in the chat box, and we will answer the questions for you as they come up. Presenting today, we have Assistant City Clerk Nakima Newsom, Jeremy Peterson from ISD. He'll be presenting on cybersecurity. And then we have Deputy City Attorney 3, Katie Dorr. So first, I'm going to turn it over to Jeremy. Go ahead, Jeremy.
Good evening, everyone. I'm going to be talking to you a little bit today about cybersecurity. As new boards and commissioners, you should have all received an email from your department liaison, and this is used to set up your city email account. Once you are able to set up your city email account, you'll have a given period of time, typically 48 hours, in order to complete the cybersecurity training. And this is in order to keep you and the city safe from any unwanted attacks. It's also important to note that if you were a previous board or commissioner, you don't need to take the cybersecurity again in order to set up your account, but everybody, including city staff, will take cybersecurity training in October. So it might seem like you just started as a board and commissioner and you got the training in order to set up your account, and then you get another one shortly after. That is standard procedure. So every October, expect that. If you have served on a board and commission before, then you will not need to take it 48 hours after setting up your account. If you've already done that, then that's great. If you have set up your account but didn't have an opportunity to take your cybersecurity training, it will automatically lock you out of your account after a certain period of time, and so you'll need to reach out to the ISD help desk, and I'll throw the phone number for that in the chat in a little bit. Another thing I wanted to talk to you about is just the policies and procedures for using city emails. So it's important to note that California is under the Public Information Act. So anybody that is now using public email will have, the public has a right in order to access that information for whatever reason. So it's in order to find out more information about any official communications that's happening. As a result, you'll want to make sure that you're always using your city email account when you're communicating about city business. So if you were to use your personal email account for whatever reason, then that is now subjected to the Public Information Act under the state of California. So wanting to protect everybody, make sure you avoid that. The other thing is that the city emails are backed up for 2 years at a time. So if for whatever reason somebody wants to request information going back, in an extended period of time, all of that's backed up and taken care of by the city's IT department. So you don't need to worry about that. So just want to emphasize that it's really important to only use the city's email address when doing any official communications for the city. Again, I'll throw the phone number for our IT help desk in the chat. If you have any questions, we have a great team that's available 24/7 to be able to help you with that. And Denise, that's all I have. I don't know if you want me to pause for questions.
Are there any questions regarding what was just presented?
If we have not received an email to set up our email, should we contact you or the person who's been contacting us?
Yeah, it's a great question. So your department liaison will be the person that's responsible for helping you set that up initially. So please reach out to them. And then if you have any issues once it's set up, then IT will be able to help you out.
Okay, any other questions? No? Okay, thank you, Jeremy.
You're welcome.
Okay, so next I'm going to ask for Nikki to put the slideshow up. So so first what we're going to be talking about is initially we're going to be talking about the Brown Act. You can go ahead, Nikki. So the Brown Act is the state law which governs the meetings of all local legislative bodies and ensures that the public's business is done in public so that the people may retain control of their government. The Brown Act is found in Government Code Section 54940. And so this is it's the basic legal rule that's imposed by the Brown Act, is that all meetings of local legislative bodies must be open, noticed, and accessible to the public. So that's just kind of the basic. Did I see the phone number's in the chat, by the way. Okay, so so this is regarding the Brown Act for public agencies, which we are, and it exists to aid and conduct the people's business. So it is intent, as I said, the law is taken so that the meetings are held in and open and that they're deliberated and conducted openly. The people of the state do not yield the sovereignty of the agencies which serve them. So the people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. So the people insist that the remaining be informed so that they may retain control over the instruments that they have created. So again, this is just the basis of the Brown Act. Go ahead, Nikki. Next slide. And again, all meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency except as otherwise provided for in this chapter. And all of your boards and commissions, I believe, are Brown Act bodies because they are established by the council. Go ahead. So let's talk about what constitutes a meeting. So any congregation of a majority of the members of the legislative body at the time and location to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. So again, this is the same location and time, which is why you have that in your bylaws when you're going to meet, are covered and considered a meeting. So meetings are not limited to face-to-face gatherings. They include communications by telephone, computer, smartphone, text messaging, social media apps, and other forms of communication. And we'll go into that later. Next slide. So what is prohibited are serial meetings. And so the Brown Act expressly prohibits a majority of the members of a legislative body form outside of a meeting using a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. So a prohibited serial meeting is a series of communications, each of which involves less than a majority of the legislative body, but which taken as a whole involves a majority of the body. So as a result, deprives the public of the opportunity to meaningfully participate in discussion. Next slide. So here are two types of prohibited meetings, serial meetings, that are considered serial meetings. So first we have the daisy chain. So an example, so member A contacts member B, and then member B contacts member C, and then member C contacts member D, until a quorum of a collective concurrence or understanding of some kind has been reached. So for example, the council has 7 council members, so this would be 4 members. So that's now a quorum. And so the conversation is being had and a decision is being made concurrently through the collective. So that means that the decision's been made and it wasn't done in public. Next, we have the hub and spoke. So if you have a staff member, this is an example, staff member or legislative body member that acts as the mediator and the hub. So they're communicating with other members one by one to reach a decision. Again, these are prohibited serial meetings. Next slide. AB 992. Did I hear someone? Oh. AB 992 addresses serial meetings on social media. So serial meetings prohibition does not prevent a member of a legislative body from engaging in separate conversations or communications on an internet-based social media platform to answer questions, provide information to the public, or to solicit information from the public regarding a matter that is within the subject matter jurisdiction of the legislative body, provided that a majority of the members of the legislative body do not use the internet-based social media platform to discuss amongst themselves business of a specific nature that is within the subject matter jurisdiction of the legislative body. So an example of this would be if a member of your body is on social media and they want to talk about a subject that comes up, and that's fine for them to do, and they can give their opinion about it, but you can't have, again, a quorum of the members respond to that discussion or be involved in that discussion. Next slide, please. AB 992 also says internet, it gives an example, gives a definition, internet-based social media platform. It applies only to communications on online social media platforms that members of the general public have the ability to access and participate free of charge and without the approval by the social media platform or a person or entity other than the social media platform, including any forum or chat room, and cannot be blocked from doing so, except when the internet-based social media platform determines that the individual violated its protocols or rules. Discuss among themselves means communications made, posted, shared on an internet-based social media platform between members of a legislative body, including comments or use of digital icons that express reactions to communications made by other members of legislative bodies. So that would be emojis, thumbs up, that sort of thing. Prohibition on direct response. A member of the legislative body shall not respond directly to any communication on an internet-based social media platform regarding a matter that is within the subject matter jurisdiction of the legislative body that is made, posted, or shared by any other member of the legislative body. Okay, so application to nominated board and commission members. The Brown Act expressly provides that any person elected to serve as a member of a legislative body who has not yet assumed the duties of the office shall conform his or her conduct to the requirements of this chapter and shall be treated for the purposes of enforcement of this chapter as if he or she has already assumed office. Next slide. Remedies and penalties. Criminal penalties for willful violation are covered under Government Code 54959. Civil relief to prevent or stop violations has Government Code 54960. Civil relief to void prior actions is Government Code subsection 54960.1 and .2. And attorney fees and costs may be awarded in a civil proceeding for relief if it is found that the legislative body violated the Brown Act. Next slide. I want to talk about meetings. So the Brown Act generally requires that the council posts an agenda 72 hours prior to any regular meeting that describes items to be discussed and prohibits any discussion of or action on any item not listed on the posted agenda. Where a member of the public raises an issue that is not agendized, the legislative body may very briefly ask a clarifying question, provide information to the public, or provide direction to its staff to place the item on the agenda for a future meeting. The public can talk about anything, but the council generally cannot act or discuss an item that's not on the agenda. So for meetings, no registration for attendance. A member of the public shall not be required as a condition to attendance at a meeting of a legislative body of a local agency to register his or her name, to provide other information, to complete questionnaire, or otherwise to fulfill any condition precedent to his or her attendance. So I don't know if you guys are aware of that, but we, most of us just request that a member of the public give their name and they just provide basic information to speak. It's not required, but it is something that we do ask. We would prefer, I mean, it just makes things run easier and you're able to put it included in the minutes. Right to record. So any person attending an open and public meeting of a legislative body or local agency shall have the right to record the proceedings with an audio or video recorder or a still or motion picture camera in the absence of a reasonable finding by the legislative body of a local agency that the recording cannot continue without noise, illumination, or obstruction of view that constitutes or would constitute a persistent disruption of the proceedings. And then there's no secret ballots. So no legislative body shall take action by secret ballot, whether preliminary or final. So all votes are taken out in public, in person, so everyone can see it. Now, regarding public comment, required, every agenda for a regular meeting shall provide an opportunity for members of the public to directly address the legislative body on any item of interest to the public before or during the legislative body consideration of an item that is within the subject matter jurisdiction of the legislative body, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by a different subdivision, by subdivision section 54954.2. Now, reasonable rules. The legislative body of a local agency may adopt reasonable regulations to ensure that the intent of the subdivision A is carried out, including but not limited to regulations limiting the total amount of time allocated for public testimony or particular issues and for the individual speaker. For public comment, a commission may not censor public comment. It may not refuse to publish written comments it deems inappropriate or mute public speakers during its meetings. The Brown Act prohibits legislative bodies from enacting regulations prohibiting public criticism of the policies, procedures, programs, or service of an agency, or the acts or admissions of the legislative body. Disruptive conduct. If a commenter becomes disruptive, they may be removed after the presiding officer first provides a warning to the disruptive individual that failure to cease their behavior may result in removal. Disruptive means a behavior that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting. So let me talk about quasi-judicial hearings and fair process. Some commissions, for example, Planning Commission, Landmarks Commission, make decisions affecting specific parcels or projects that require findings based on facts. To ensure applicants receive due process, commissioners should only consider the facts before them at the hearing and should refrain from making decisions or announcing their opinions before the matter is heard, including all public comment. Commissioners should not attend community meetings about the project. At the beginning of the hearing, commissioners must disclose any outside communication or independent investigation about the project. Ensure the decision is based on factual evidence in the record and that findings are supported by substantial evidence. Okay, now I'm going to turn it over to Assistant City Clerk Nakima Newsom.
Good evening, everyone. I'm going to talk a little bit about the Public Records Act, or the Sunshine Laws. Members of the public have a right to inspect and receive copies of public records. Public records include all writings containing information relating to the conduct of a public's business that are prepared, owned, used, or retained by city employees. Public records include records on personal devices such as text messages on personal smartphones. Requests made or forwarded, or I'm sorry, requests are made and forwarded to the city clerk. Exemptions are determined by the city attorney's office, and it may include any item that's of attorney-client privilege or certain law enforcement and personnel records. And there are sanctions, including the award of attorney's fees for the violation of the Public Records Act.
Did we lose her?
I'm sorry. I hit the wrong button. Give me a second.
I think you were on slide 16, Nikki.
Yes. Okay. Sorry about that. Okay. Next, we're going to talk about civility at meetings. So, Council adopted resolution number 10642 on December 13th, 2011, to help ensure that civic engagement and local democracy continue to flourish and to safeguard participatory democracy in Santa Monica. There are 6 guidelines for behavior at all public meetings within the city. The first is to treat everyone courteously. The second is to listen to others respectfully. The third is to exercise self-control. The fourth is to give open-minded consideration to all viewpoints. The fifth is to focus on the issues and avoid personalizing debate. And the sixth is to embrace respectful disagreement and dissent as democratic rights, inherent components of an inclusive public process, and tools for forging sound decisions. Some practical guides for demonstrating civility and respect. Civility is not simply being polite or keeping silent. It is about encouraging everyone's right to speak their mind in a professional and respectful manner. So first, before acting or speaking, consider the impact of your words or actions on others. Rely on facts rather than assumptions, and then take the time to gather relevant facts before acting or committing to an action based on the assumption. Understand your triggers or hot buttons. Knowing what makes you angry and frustrated enables you to manage your reactions and respond in a more appropriate manner. Adopt a positive and solution-driven approach in resolving conflicts. And if someone is behaving in an uncivil manner, respectfully inform them that you want to hear and understand their concerns and that you would like to continue the conversation if you can proceed in a civil and respectful manner. And all of your agendas should have the civility code printed on them as part of the template. If you don't see that, you might just want to remind your liaison that the civility code should be printed on the agenda. And we do encourage the chairs to read the civility code out and during the public meetings at the beginning of the meeting. Next, we'll talk about abusive conduct or bullying. Abusive conduct goes beyond mere incivility. State law defines abusive conduct as conduct of a person in the workplace with malice a conduct of a person in the workplace that acts with malice that a reasonable person would find hostile, offensive, and unrelated to the city's legitimate business interest. It includes verbal abuse, derogatory remarks, insults, epithets, threatening, intimidating, humiliating, physical or verbal conduct, or undermining a person's work performance. Some examples of abusive conduct or bullying behavior may include spreading misinformation or rumors, behavior, language, or gestures meant to patronize, frighten, humiliate, intimidate, or demean, including criticism or feedback delivered with yelling, direct or implicit threats, insults, or offensive language. Repeatedly demanding a person to perform tasks that are inconsistent with their job or outside their job responsibilities or authority, refusing to take no for an answer when the person is within the right to decline a demand, or pressuring a person to provide information that they do not have or are not authorized to release. Sabotaging or undermining a person's work performance, and circulating inappropriate or embarrassing photos, videos, or information via email, social media, or other means. Now we're going to turn it over to Deputy Attorney Katie Dorr for the completed presentation.
Thank you, Nikki. I'm going to switch to my version of the PowerPoint here. Get it to pop up. Okay. Skip ahead. Okay, so this is where we left off. Okay. I'm going to talk mostly about ethics and ethical rules. Under state law, you're all required to take ethics training, which is commonly known as AB 1234 training, within 1 year of your appointment, and every 2 years thereafter. That's a very comprehensive 2-hour training. The FPPC provides a free training available on their website. So I'm not going to reiterate everything that's in that training. I'm just going to hit on sort of some high-level highlights and some things that are unique to the city of Santa Monica. So in the year 2000, the people of Santa Monica voted to amend the city charter to include specific ethical guidelines beyond those required by state law. As a public official, you have a duty to make decisions for the benefit of the public and not for your own personal gain. General ethical principles are to act for the public good, not for personal gain. Avoid actions that would cause the public to question whether decisions made by the government, including your board or commission, are based on private interests rather than the public interest. Cultivate public trust in the government process. Support the public's right to know. Safeguard public resources and treat every person with dignity and respect. So in 2015, the City Council adopted the City Code of Ethics that applies to all city boards and commissions based on the guiding principles of fairness, integrity, transparency, and accountability. And these are the principles that should guide your decisions as public officials. So this slide shows the layers of ethical regulations throughout federal, state, and local law that regulate the actions of public officials. They're all primarily based on the premise that you should not participate in a government decision in which you have a financial interest. You should be acting in the public's interest and not your own interest. And in most cases, officials do not violate these laws if they disclose the financial interest and abstain from participating in or seeking to influence decisions in which you may have an interest. Just know that ethical rules can be complex and there's layers of exceptions that apply. So if you do have a question or you are afraid you may have a conflict, City Attorney's Office is here to help. You can always reach out to us through your staff liaison and we can help you determine whether or not you may have a conflict on an item. As you can see, and as I'm sure you're aware, there can be serious penalties for ethical violations. And in addition to briberies, kickbacks, fraud, embezzlement, and tax violations, note too that vote trading is illegal under the California Penal Code. So you can't tell a fellow commissioner that you'll vote on something that they support in exchange for their vote on something that you support. So Government Code 1090. Under Government Code 1090, a public official shall not be financially interested in any contract made by them in their official capacity or by any board of which they are a member. The California Attorney General has concluded that Government Code 1090 does apply to bodies that are purely advisory. And the making of a contract includes all of the preliminary steps that go into its formation. So even if your body is not the one that's actually making the decision, even if it's ultimately a decision of the city council, the actions of your body is a preliminary step going into the making of that ultimate contract. But if a body is purely advisory, then the ultimate decision maker, the city council, may still enter the contract so long as any financially interested member of the advisory body abstains from any conduct or discussion involving that contract. The Political Reform Act. Under the Political Reform Act, an official has a financial interest in a decision if it is reasonably foreseeable that the decision will have a material financial effect different from that of the public generally on the official's economic interests. So the Political Reform Act really has two main tenets to it. One is disclosure. Many of you have or will be filing Form 700s within 30 days of taking office, which discloses all financial interests that may be affected by the decisions you make in your official capacity. And the second is disqualification when you have a disqualifying financial interest. So what do you do if you have a financial interest that requires you to recuse yourself? You may not participate in any way, not just in the vote, but in anything leading up to the vote on that item. So it's important to let your staff member know or let other commissioners know that you have a conflict and you can't talk about the item. And then during the meeting, when the item is called, you can state on the record that you have a conflict and the basis for that conflict, and then leave the room until the item is concluded. Revolving door and the Oaks Initiative. I know that you're all just beginning your journey as commissioners in most cases, but there are some ethical obligations that will continue even after your term is over. As a member of a city board or commission, you may not directly or indirectly negotiate future employment or future business opportunities with a person who has a matter pending before a board of which you're a voting member. And you're also prohibited from using your city position to influence a city decision involving the interests of a person with whom you have an agreement for future employment or business opportunities. And under the Santa Monica Oaks Initiative, if you vote to approve a contract or land use approval, you can't accept a personal or campaign advantage from that person or entity for a period of 2 years after you leave your public position. And there's similar provisions to that under state law as well. Common law conflicts of interest. While Section 1090 and the Political Reform Act are the primary state laws, there's also an amorphous body of common law conflict of interest based largely on case law, which is targeted at just ensuring that public officials making public decisions aren't doing so based on personal bias. So even if you can't pinpoint a statutory prohibition, if you find yourself in a position where due to your personal interests, you feel you can't act objectively in the public's best interest, you have a duty to recuse yourself from a decision or from an item. Gifts and perks. Be aware that as a public official, you may be required to report gifts you receive. A gift is defined under the Political Reform Act as anything of value for which you don't provide payment or services of equal or greater value. There are, of course, exceptions for the most common types of gifts that we receive, which are gifts that are received via social or family relationships that have nothing to do with your public service. But the gift rules are intended to reduce improper influence on public officials. So disclosure is required for gifts over $50 from a single source, and you must disqualify yourself on a decision involving a party from whom you may have received gifts that aggregate $590 or more over the course of the calendar year. And when you assume office and you're doing that initial assuming office Form 700, you must disclose any gifts you've received during the 12 months prior to the date that you assumed your position. Any gifts to which there is no applicable exception. Use of city resources. It is unlawful for any elected state or local officer to use or permit others to use public resources for a campaign activity or personal or other purposes which are not authorized by law. So the basic principle here is city resources should be used only for city business. This includes use of city letterhead, use of city email accounts, copiers, computers, use of city employee time, use of conference rooms, etc. So there are some de minimis exceptions, like if you get an email from your personal account, it's not against the law to respond to the email, although it's not best practice. But keep this in mind as the general rule. AB 1234 training. If you haven't yet done your required AB 1234 training, here's a link at which you can find the online training. And I recommend you do it as soon as you can. There's a lot of important, valuable information there. And in any event, you're required to do it within a year. Once you have completed the training, I believe you report your completion to the city clerk, who keeps a record of it. If you have any questions about potential conflict issues, as I mentioned earlier, contact the city attorney's office. Either you can contact my office directly or through your staff liaison, and do so as soon as you can, so that we have a time to analyze the facts of your potential conflict and to provide you with an analysis. Worst case scenario, but this happens all the time, is a commissioner will come up to us during a meeting and say, "Oh, I think I may have a conflict on this." And at that point, it's difficult to do the analysis, so it's always better for you to contact us as early as possible if you think it's even possible that you may have a conflict. Attendance policy and remote participation. So the city does have attendance rules for its commissioners. For commissions that meet monthly, members accumulating 2 unexcused absences over the course of 6 regular meetings automatically vacate their membership on the commission. Members with 2 or more excused absences from any 6 consecutive meetings shall receive a warning, and if 2 more meetings are missed, the city clerk shall inform the city council. So if you need to miss a meeting, let your chair of your commission know and your staff liaison know as far in advance as you can. Excessive absences can result in commissioners being removed from their respective commissions. Remote participation. So unfortunately, in the post-COVID era, meetings have moved back to being in person. Currently, the city does not have the ability to hold hybrid meetings with some members attending in person and some online. So if you do need to call in to a meeting, you are able to do so subject to the Brown Act rules on telephonic participation, but there's specific requirements that must be taken into account. First, you must participate from a public location and you must post the agenda at that location. So that means, for instance, if you're on vacation, you can't participate from your closed hotel room. You must participate from the hotel lobby or the business center or some other specifically identified publicly accessible room. And the hotel needs to post the agenda in a public place. The public must be able to participate from that location, however unlikely that may be, and you should be listening to the meeting on speakerphone. And just anecdotally, I have had instances where, say, there was a contentious union contract before our council, and one of our council members was in Mexico, and the union actually sent a member down to look and make sure that the agenda was posted properly and that the member was abiding by all the rules. So however unlikely it may be that somebody may want to participate from your remote location, you still have to abide by these rules. And I think that concludes the presentation for tonight. I know this was a lot of information, but I think that you'll be provided a copy of the PowerPoint if you want to go back through and review it. And does anybody have any questions? Doesn't look like it.
I do.
Okay.
I am in the Housing Commission. My name is Deborah. I'm new. And I'm actually having knee replacement surgery in a week and a half. And I'm going to miss, well, I could attend the next meeting, through Zoom or some other source, but do they have to then post my home address?
So yes, you can only participate from your home if you're willing to have the public at your home participating with you. So it's not ideal, right? So I mean, yeah, potentially you could be in your driveway.
I live in an apartment building with 46 other units. It's literally impossible.
Right. So that sounds like probably a meeting that you would tell your staff liaison, I'm not going to be able to make it, and it would be an excused absence for you. And you can still watch or track the meeting. It would just be difficult for you to participate.
Okay. Thank you.
Anybody else? Denise, Nikki, you have anything else?
No, I was just going to say if anyone, I was just going to ask one more time if anyone else had any questions. Okay, so it doesn't look like it. So I want to say
Oh, we do have
thanks.
somebody.
Oh, okay.
Ann
Ann
There's
Bowman.
Ann. Go ahead, Ann.
Hey, sorry to bother you all. So I went to coffee with one of my fellow commissioners to get to know them, and we each paid separately for our coffee. But the commissioner said, oh, actually, I could buy you coffee and a snack up to $25, and you could do that for me, so long as it doesn't within a calendar year exceed the $590. Is that correct or not correct?
That's not correct.
Okay, help. Thanks.
So the threshold is $50 for gifts, but there's exceptions for if you have friends and you reciprocate buying lunch for each other once in a while. That sort of thing is not necessarily a reportable gift, but it is something you need to keep tabs on, because if it starts to add up, then that's becomes something that is then reportable. And the threshold, like I said, it's $50 for a gift and it's $590. That's the threshold at which you would have to recuse yourself entirely from items involving that gift giver.
Okay, got it. Thank you so much.
And I would add too that the FPPC on their website has a lot of really good resources relating to gifts. So if you poke around on there a little bit, there's some really good information.
Okay, anybody else?
We have a question in the chat. Should our staff liaison be sending the link for the additional ethics training? And that question is actually yes. Actually, the liaison, you should have received actually a letter from our office inviting you or to instructing you to take the AB 1234 training after you were appointed. So I will follow up with our staff to make sure you do get that information, Dana.
And just a note about that training, it's a 2-hour training, which means if you speed through it, it'll make you take supplemental courses until you hit 2 hours. So it's not it's not like traffic school where you finish it as fast as you can. You have to do a solid 2 hours of training.
I actually took it and I went very slowly, but I worked for the state of California for 17 years, so I finished it and the supplemental in 1 hour and 45 minutes, and it still issued me the form.
Oh, good.
You got lucky then.
Yeah, right.
I've heard of
really
people where
tried
they jumped off 10 minutes early or even 5 minutes early and they did not get their certificate. So
Okay, anybody else? No, not seeing any hands, not seeing any. Okay. All right. Well, thank you everyone for spending this time with us. I hope it was beneficial to you. Nikki has sent an email. We'll send out an email. We'll have your staff liaisons. We'll send it out to all of you of this recording and the slideshow. So remember, if you have any questions, contact your staff liaison. If you have legal questions or ethical questions, reach out to your staff liaison or the city attorney's office. So on that note, Nikki, are you going to turn the recording off now? So thank you, everyone.
Yes.
Have a good evening.
Okay,
We appreciate you being here.
thank you.
Thank you, everyone.